Welcome everyone to this third episode of the podcast series Environmental Justice Litigation. This podcast is a student project at the University of Oslo. My name is Konrad Sandvik and I'm here with Iva Svalina. So tell me, Iva, who are we talking to today?
So today we are talking to Ivar Alvik. Ivar is a law professor at the Department of Energy and Resources Law at the University of Oslo. We are hoping to get the explanation of Norwegian licensing system, which can seem a little bit complicated at first, and also, of course, some legal comments on this case. If you don't have anything to add, I think we can go further to the interview.
So with us today we have Ivar Alvik, professor at the Scandinavian Institute of Maritime Law, Department of Energy and Resources Law at the University of Oslo. So thank you so much for being with us today, Ivar.
Thank you for having me.
It's a pleasure. So first of all, I was wondering if you could quickly explain from your perspective what the Norwegian climate lawsuit was and how it unfolded in the courts.
Yeah. From my perspective, this was a court case which was launched by some environmental interest organizations against the Norwegian government, where the basic claim was that a round of concessions on the Norwegian continental shelf, more specifically the 23rd round of concessions, which was handed out by the Norwegian government, was illegal and invalid as a result of the concessions being in violation essentially of Section 112 of the Norwegian Constitution. As I perceive the case, it also revolved around basically two main issues. The first issue was whether this round of concessions was substantively in violation of a material standard for protection of the environment enshrined in Section 112, and the other main issue, as I understand it, was that the round or the process leading up to giving out the concessions was in breach of a procedural requirement, essentially enshrined in Section 112, but in practice this was a little bit more complicated because you also had the procedural requirements in the regulatory framework, both the Norwegian regulatory framework and also an important EU directive, the so-called planning directive, which was important.
So can we start a little bit from the technical questions? So can you explain Norwegian licensing system in short?
Yes, I can do that. The Norwegian licensing system is it's based on different stages. It's a decision-making process with different concrete stages. The first stage in the licensing process is that the area where these licenses are situated or located has to be opened for petroleum activity. It's not expressly said in the regulatory framework that this is a decision taken by the parliament, but in practice it is. So it is the parliament which, based on impact assessments, etc., which the executive government and the Ministry of Petroleum and Energy prepares as a white paper before the parliament. The parliament then decides to open up an area for petroleum activity. So essentially, for petroleum licenses to be able to be given out to participants, the area has to be opened. There has to be this decision relating to each new area. This is quite a massive procedure. There haven't actually been that many openings of areas on the Norwegian continental shelf. But the last decision to open was in 2013, and this related to the southeastern part of the Barents Sea, where many of these licenses in the 23rd license round was handed out. But the other area where there also were some licenses that was opened in 1989, as far as I recall. That was the southern part of the Barents Sea. So this is the first stage, the opening of areas. After an area has been opened, that means that it is subject to potential giving out of licenses. So this then is the next important decision. That is the decision to give individual licenses to interested companies. And this is this decision is a decision which is taken by the executive, the king in council, which is the expression in the Norwegian Petroleum Act. And the king in council means that it is subject to a formal process where it is the cabinet which decides, but it has to be countersigned by the king in a formal meeting.
So this part of the process doesn't require assessment, right?
No, that's correct. The licensing as such, the round of licensing doesn't require an impact assessment as such, because the impact assessment relating to the environment, etc., will have been made in the opening of the area. But that doesn't mean that there isn't elements of an impact assessment also in relation to giving out individual licenses. But the most substantial impact assessment is in the opening of areas. What is also important to know is that this handing out of individual licenses doesn't as such give a right to produce any petroleum. It is mainly a right to explore. It's both a right and a duty to explore for petroleum in a certain area. And then it is also it also provides an exclusive right to produce. But the main part here is that the right is exclusive, meaning that no one else can be given a right to produce. It doesn't mean that you having the exclusive right actually have a definitive right to produce, because this then is subject to a new decision which is the so-called approval of the plan for development and operation. And this approval of the development plan, that is also subject to very detailed requirements relating to impact assessments. There has to be an impact assessment relating to environmental consequences, economic consequences, and this is, of course, it is only at this stage that it is possible to make an individual impact assessment relating to the licensing question, because in relation to the opening, one obviously doesn't know whether there is any resources to be developed.
So an organization like Greenpeace, for instance, are stating that the Barents Sea area is very delicate, and the area around the ice edge is also an important ecosystem that oil production could damage significantly. So presumably, where in the process would you evaluate if this area is too delicate for oil production?
You would evaluate it in both stages, both in the opening of the area as such, where this is precisely what would have to be subject to be the subject of the impact assessment. So, for instance, in relation to what is at the moment and has been for some time a contested area, which is outside the Lofoten Islands. That area has not been opened precisely because of such concerns. But also in relation to the development plan, there has to be an assessment of these consequences, because it is only in relation to the development plan that you are able to make an individual assessment of sort of what types of installations you will require to produce, where these installations will be, what are sort of the individual qualities of the reservoir, what types of risk does this entail, etc. These are things that you don't know anything about when the area is open. There you just have more of a sort of general awareness relating to the environmental implications. But you don't have sufficient knowledge to sort of make the individual assessment. And that is also then why you have to make this sort of assessment in both stages of the process.
When you make that individual assessment, you would weigh stuff like how delicate the area is, how much oil there is potential, how much gain you could have from extracting in the area, the risk of spills and stuff like that. Yeah,
exactly. But that would be in the opening. But you also you have to make this assessment once more in relation to the development plan. So sort of having decided that this is a potential area for production doesn't mean that you have sort of decided that there will be production. You have sort of just made the decision that this area is potentially sort of it's an area having the potential for petroleum production. But you can't make sort of a definitive assessment of that in the opening process.
But what we have seen from the case, that it was highly disputed whether the combustion effects abroad should be included in the impact assessment. Can you comment a little bit that part?
Yeah, that was one of the key issues in the climate lawsuit, was whether the combustion, that is the emissions from exported petroleum and the combustion of that petroleum abroad, should also be taken into account in the impact assessment. That is, I think, unclear from the wording of the relevant provisions. That has to do with the procedural requirements. What is said in the procedural requirements relating to opening is that climate consequences have to be taken into account. But what is meant by climate consequences, that is not clear. One possible interpretation is that climate consequences means consequences of the burning of petroleum in the production process. And I think that is probably how it has been interpreted before by the government, whereas the environmental organizations argued that this also should cover burning of exported petroleum.
Yeah, so from what I understand, when you make the impact assessment, you account for the income you will have from exporting the oil, and you account for the possible increase in CO2 emissions from combustion in Norway, but you don't account for the oil you export to other countries to be burnt there. We sort of don't account for the increased emissions that will arise from that. And the environmental organizations think that since the paragraph says the government should have a role in trying to establish a better climate, we should also care about what we are dealing, like selling to other countries, and how that would impact the environment. But did the court have any decision on this area?
Yes, the court was divided on that exact question. The majority of the court argued that there wouldn't be much point in making an impact assessment relating to possible emissions in the opening stage of the process. Because they argue that at this point you don't know whether there is any petroleum in the area, you don't know how much petroleum there is, and you don't know whether that petroleum will be worthwhile to produce. So the majority, quite a large majority of the court, held that this was an evaluation which, if it was required at all in the process, which they sort of didn't really make an opinion on, I think, but if it was required, it would be more suitable, or it would be better to make that assessment in relation to the approval of the development plan. Whereas the minority, essentially on the basis of an interpretation of this EU directive that I mentioned, they argue that this also was something that should have been taken into account as a procedural requirement under the opening stage of the process. What is a little bit interesting there is that they argued, and also, as far as I understand it, also the claim of the environmental organizations was that this concern or this requirement only attached to the area that was opened in 2013. Which, as far as I recall, at the time of the judgment, only covered one of the licenses in the license round. The other licenses subject to that opening statement had been redelivered to the government at that point. So the remaining licenses, which was subject to the judgment, they had been opened in 1989. And at that point, it seems that also the environmental organizations agreed that it was you couldn't have expected that the climate consequences should have been taken into account that long back.
That combustion of exported oil and gas was also commented regarding the alleged violation of Article 112. And we have seen that all the three courts in the proceedings came to somehow different conclusions. We have seen that Oslo District Court said that combustion abroad is not covered. Then the Court of Appeal said it was covered. And then the Supreme Court said that it was covered, but only if the effects can be seen in the Norwegian territory. Was that how it was?
Yeah, I agree with you that that the judgment of the city court basically was that section 112 only covered emissions in Norway. Then my perception of it is that the appellate court and the Supreme Court essentially agree that you can't make that sort of restrictive interpretation of section 112. So in principle, it covers also burning of petroleum abroad, but subject to the requirement that this burning of petroleum abroad must have potential consequences in Norway. Then, as far as I read the judgment, I think that the appellate court also made that, also interpreted the provision in that sense. So I think that the appellate court and the Supreme Court actually was in agreement on that point. But it's not an issue which is very heavily argued by the Supreme Court, one could say, or one would have to say. It's not something they sort of go very much into. They just sort of state that this is how it has to be interpreted.
So you have written an article about the first Norwegian climate litigation. And in that you state, among other things, that, let's try to sum it up, that you think that would be a hard and, I think you used the word pointless exercise to try and establish the environmental impacts of, or the global impacts of exporting oil that's going to be combusted anywhere else. Can you explain what you mean by that?
Well, I wouldn't agree that that's actually what I say. At least that's not what I mean when I write the article. What I mean to say is that balancing the global climate implications of this sort of quite limited part of Norwegian petroleum production against the benefits for Norway of increasing our production is close to a pointless exercise, because you are comparing unequal things, basically, because the benefits to Norway as a producer country will be very tangible. We will gain a lot. There will be a lot of money involved for the Norwegian state, whereas sort of the production from this round of licenses, the global climate implications of increasing Norwegian petroleum production with the possible amounts that you might find in this license area will be quite limited, because they will sort of go into sort of the whole of the cumulative effect of all the global emissions around the world. So that means that balancing is very difficult to make. What would be a more meaningful discussion, obviously, would be whether Norway should sort of take a lead among producer countries in trying to limit global emissions with a binding agreement for all or many producer countries. That is sort of that is something one could envisage. But when in that exact balancing, you would have sort of the very tangible effects of increasing Norwegian production on the one hand for the Norwegian economy, and on the other hand, you would have the either very marginal or perhaps no effects at all of increased Norwegian production, because that the question of what impact increased Norwegian production will have on on global consumption is extremely complicated.
And it's one of the problems, like inherent in climate change, of course, that it's easy to have almost like a free rider problem, where you would want emissions to be cut elsewhere, of course, because you want to get the tangible benefits, as you say, in your own country. So it's just, as an economist, when I think about societal efficiency, for instance, and looking at it at a global scale, I think it's easy when making these assessments, if we only account for the benefits to the country extracting and exporting the oil, and we don't consider the impacts to the global climate, that the total negative effect of the increased extraction will actually outweigh our benefit. It's just that we are the ones in the position to make the assessment and make the decision. And then, of course, you would, in a lot of cases, end up with some inefficiency, like taking some choices that, in the global scale, might not make sense. But did the court find any reason to say that we, of course, they can't establish such a system. They're not meant to establish like the formula of taking into account. But did they say that we should have such a system, or could they have said that?
Well, I think that was part of what the majority and the minority disagreed about. I think that the majority essentially said what I said. If you sort of strip away all the legal argumentation and sort of cut down to what was the core of the argument, was that making or doing this sort of balancing as part of an impact assessment at the opening stage would be a rather pointless exercise, because you don't know what the effects of increased production will be. You don't know whether there will be any increased production. You don't know whether there will be any petroleum that can be produced, etc. So you would have to make very sort of sketchy estimates. And what you could say something about is, of course, that increased production will have some effects on the market, etc. But I think, as I read the majority, they say that this is something that it is possible to have a political discussion about. And they also pointed to the process in the parliament where this was actually discussed. There was much discussion around this question in the opening decision in 2013. And it said that is the proper place for that consideration, because in the form of an impact assessment, you can't really say anything. That was what they argued. And then you had the minority, which had a slightly different view. They also said, as I read them, that there's a risk that this may be close to a pointless exercise. But at the same time, they said that it is possible to make some assessments. And they argued then that these assessments, because of the importance and sort of along the lines that you argue, could have been made part of the impact assessment. Therefore, in view of the importance of the question, etc., and also as far as I read them, in view of sort of serving to remind people of the importance of these questions, that in itself would sort of have a value to put into an impact assessment.
And in the impact assessment, we do account for the increase in emissions that will occur from combustion in Norway. But can you explain why we care about the Norwegian combustion from the oil? And not the combustion in other countries from the same oil field?
I think people probably can have different opinions on that. I think the easy answer is that this is how this has been interpreted before. But also, I think there is an understanding here that this is how the international system for combating climate change has sort of provided for, that this is how it shall be done. So I think, as far as I have understood it, the international law in this area is based on precisely the distinction between burning in other countries and the production in your own country. And the basic argument, or the basic understanding, is that what countries have responsibility for is the consumption in their own country, not their exports to other countries.
And that is kind of, as you said, the standard established by the Paris Agreement, that you're looking at the combustion within each country, and in a way that makes Norway look very green. We have a lot of renewable electricity and a lot of electric cars, but then on the other hand, we are a big exporter of like fossil fuels. But in a climate accounting exercise right now, we look like a very green country, which I think some of the environmental organizations thinks it's almost hypocritical in a way. But you said in the same article we referenced earlier that you had an example of littering as a parallel to the climate problem. Can you go into that as well?
Yes, well, the way I perceive the climate problem is you can make the analogy to throwing litter on the street, or basically to throw litter around. If you look at it from one person's individual perspective, there's no there won't be sort of any much added harm done if everyone else throws litter around, if you also do it. And you could say that this is, in a sense, the same that you have in the petroleum, in the discussion relating to production of petroleum. You could say that if Norway stops producing petroleum or stops exploring for petroleum, that won't have any effect on the global climate if all other producing countries continues. But that, of course, isn't necessarily morally an excuse for continuing to explore for petroleum and continuing to produce petroleum. Because if everyone thinks like that, no solution to the question will ever be found. So yeah, that's the analogy.
That is a problem, of course. So I will ask you perhaps a tricky question. Could you try and translate the environmental paragraph to that example? What would an environmental paragraph look like in the parallel of a world where where there is excessive littering?
Yes, well, I think that that is a good question, because the question is, what sort of commitment does Section 112 in the Constitution lay on the government? And what is important here, and what, at least from the interpretation that the Supreme Court does, is that this places some commitment on the government that is also subject to judicial review. But the problem also is, of course, that what the level of Norwegian sort of activities to stop littering, if you take that analogy, or to stop producing petroleum, what level of activities should the government engage in? That's not necessarily something that is properly a legal question. It is something that it is possible to have different political opinions about. And the Norwegian system is based on the premise that those decisions, that sort of decision, should be made subject to the democratic process in the parliament. And that is, of course, also why the court is so hesitant to go in and review the government policy in this case, because the government policy here is something that has been subject to a very detailed democratic process. There has been different political opinions, and then the majority of the parliament has reached a decision. And then people might legitimately mean that Norway should do more. Obviously, that is a legitimate political opinion. But it is not something that you can say follow from the constitution by way of law, because what you do then is that you allow the constitution to become a political tool, and that is very dangerous, because then you lose the legitimacy of the constitution. Then you say that the 10, 15, 20% of the people or the parliament, which actually meant that we shouldn't open those areas, we shouldn't hand out new licenses, they are sort of if you sort of clothe those their arguments in legal terms, what you basically say is that then you have to have very strong legal grounds to do that. I'm not saying it's not possible, but there's a legitimacy question here, because it's very important that the constitution as a legal tool is there to safeguard essential legal interests.
But when we talk about the allocation of decision-making power in the climate and environmental policy between the political authorities and the courts, maybe we should comment about some critics which say that the courts are not well equipped or lack specific knowledge to decide on this matter, and it's therefore better suited for the political authorities to give decisions in this regard.
Yes, I think it's sort of another way of saying what I just said. I think that the point is that in order for the courts to be able to sort of judicially review government acts and set aside majority opinions and majority decisions of the parliament, then there have to be very strong legal grounds for the courts to do that. And it is possible that there are some interests which are suitable for that kind of judicial review. Typically, individual interests. If you have if you have a conflict between majority interest and individual interests, there might be good reasons for the court to intervene and to protect those individual interests. But if you have decisions relating to circumstances where it is possible to have different political opinions, where it is possible to have different factual understandings of the implications of the political decisions being taken, which I think the climate issue is a good example of. People might legitimately disagree on whether producing petroleum in Norway is a good idea or not in view of what is in the best interest of the global climate. One possible perspective might, of course, be that Norwegian gas is not part of the problem, it's part of the solution, because you can phase out coal by producing gas, for instance. And I think that the problem here is that these questions are very difficult, and it's possible to have different opinions on them. And I think, and I don't necessarily have a strong personal opinion myself, but I think what is important here is that the courts are not the place to make those decisions, because the courts are manned by lawyers, and these questions are not necessarily mostly legal questions. They're factual questions or science questions, etc.
And you're touching on their what kind of rights and standing that Section 112 gives to individuals or groups, and we'll touch on that in a short while. Before we move on from this, I would just like to hear your thoughts on an example we thought up earlier, just sort of another parallel and a bit more of a funny legal hypothetical, inspired by some of the environmental activist groups calling our reliance on oil and addiction. And I was wondering if we had an international agreement stating that there was a problem with drug use in the world, and we had a paragraph of the Constitution saying that our country should work to make a world with less drug use, or a more healthy environment, so to say, in the area of drugs. Would it then be in accordance with that law that we were selling drugs, but we could say that we are not using them ourselves?
I'm not sure. I think that that example is a very good analogy, but I think in order to make it a good analogy, I think you would sort of have to complicate the example much more. You would have, for instance, say you could then sort of play a little with the example and say that there are different types of drug use, for instance, and you could make the example sort of a bit more complicated by saying that the implications of Norwegian selling of drugs on global drug use aren't sort of straightforward. Perhaps you let's say that you had a number of scientists arguing that Norwegian drugs are better for drug users than drugs produced by other countries, that Norwegian drugs are safer, that in order to combat drug use, you would have to you can't stop from one day to another. You have to to give the users milder drugs, etc. So I think that in order for that example to be appropriate, you would have to make such changes.
No, I think you made it very appropriate to as to the discussion of, for instance, phasing out coal power with gas, which is of course an argument that I think makes it hard for the court to take this decision, as you said, because there are still experts in the field claiming it could be a net positive, which again highlights some of the limitations of using the legal system as climate activism, because you have to rely on the law as written, of course, and also what kind of decisions the court is suited to make. Yes, yeah. Thank you.
As Konrad said, I think we can now jump to the section 112. The Supreme Court says that it gives rights to the individuals. Can you clarify for us what could that mean in practice?
I'm not sure that the Supreme Court actually says that section 112 gives rights to individuals, because then you enter into a distinction of collective rights versus individual rights. I think what the Supreme Court essentially says is that section 112 provides for rights that can be tried by the courts. They don't say really whose rights it provides. It just says that it provides for rights which can be tried by the courts. To limited extent.
So we can say that it's more collective interest that it's protected?
Well, that would be my interpretation, at least. I think that at least in view of this case, I think that the right to a healthy climate is evidently a collective right that all citizens of Norway and basically all citizens of the world are assumed to have. So what the Supreme Court, the implications of what the Supreme Court says here is that section 112 provides for a right for Norwegian citizens to a healthy climate to a certain extent, or to a healthy environment to a certain extent. That can also to a certain extent be tried by the courts.
So from my understanding, they might have used the wording individual rights, but without much deliberation on what that would mean as compared to collective rights. Do you have an opinion on that matter, or could explain to us sort of the difference?
I think the basic difference between an individual right and a collective right has to do with the possibility of individualizing the interest that the right protects. So I think in order for, at least the way I see it, in order for something meaningfully to be spoken of as an individual right, you would have also to say that it is the right of an individual who has a distinct interest that is sort of different from the interests of other people. So an individual interest would, for instance, be my interest in not being put in jail without a proper court case. It would be my interest in not having my property taken without compensation, etc. whereas I could also be part of collective rights as a group, and I think the right to a healthy environment at this level that we're speaking about here is typically a collective right.
Because you, as you say, have an individual right, you would say, to not be jailed for no reason, for instance, and the way that right is established, it can't really be taken away from a majority of parliament, for instance. We vote that we want to put Ivar in jail because that's the majority opinion. But if the climate right to a healthy climate is more of an individual right, that more of a collective right, sorry, that would make it easier to be overruled by a majority of parliament. Is that fair to say?
Not necessarily, because I think I think that is a different issue. But I think in the nature of things, collective rights are often more difficult to make into the subject of judicial review. That is correct. But it's not necessarily the case, but I think often it is the case.
Yeah, because the argument would be that if the majority representing a majority of the country makes a decision, they're kind of setting aside their collective right for their collective interest. But if everyone had an individual right, you could not take that away from them, even if a majority of the country would want to.
Yeah, perhaps. Or you could also say that collective rights are in the nature of being vaguer than individual rights, because they are sort of less concrete. The interests are less concrete. It is sort of it is quite easy to identify my interest in my property, for instance, and the conflict of interest that there may be between my interest and the majority or collective interest in building a road over the property, for instance. That is sort of, it's easy to sort of identify the interests, but the collective interests as such are something that yeah, I think you said it quite well, that it is something that is subject typically to political argument, how best to serve those collective interests. And that is something that is usually best served by majority deliberation in the parliament or democratic processes.
So what we've learned from this court case is pretty much that Section 112 is more like a safety valve for gross environmental negligence, I think was the standard that the Supreme Court established. So in light of that, do you think that we've had any environmental gain from trying this paragraph in a climate lawsuit?
That's a good question.
Do you think it will be used again, or was this a try and now we've established it will probably not be helpful to use this paragraph in future lawsuits?
Well, I think there is a legal gain to sort of, because the Supreme Court has clarified the meaning of Section 112. And there is also an environmental gain in that the Supreme Court says that the environment is an interest, a global or a collective interest that potentially is subject to judicial review. But then again, it is correct, as you say, that what the Supreme Court, and here there's an unanimous decision of the Supreme Court, they essentially say that it is a safety valve. They actually use that word also. So they say that it is a safety valve, and that there is a very high threshold for the courts setting aside democratically made decisions.
So could you maybe imagine some case which would be better to try this climate paragraph?
That is very difficult for me to to speculate on. I think that I think that I'm not sure that this was a good case to try Section 112. If one hoped for a very sort of offensive or very sort of forward-leaning environmental stance from the Supreme Court. But then again, I think that there is an important clarification here, which does also have some environmental value. But personally, I think that the main value of Section 112, the main practical value of 112, probably isn't that it will in itself provide a likely basis for setting aside parliamentary acts, etc., but that it provides an important argument for interpreting other statutory provisions. And it provides also potential basis for setting aside administrative decisions, perhaps in combination with interpretation of statutory provisions, etc., etc. So that is where I personally would perceive that the main value of Section 112 is.
Thank you. So lastly, I just want to ask you if you could perhaps clarify a little bit what it means to have gross negligence or disregard for the environment, as they said that would be like the standard for when the court could overrule some sort of government policy.
Do they actually use the term gross negligence?
If I'm not mistaken, I think they did.
Okay, yeah, I don't recall that, but they might, and I agree that that is a possible. That would be a possible formulation or expression of the likely threshold. Gross negligence is a very high threshold. It means that ordinary negligence is not sufficient. It could, for instance, mean that someone makes a decision to do something, being conscious about this involving a high risk to the environment, for instance. That might be gross negligence. Or if you take gross negligence in other circumstances, if you do something knowing that doing it endangers someone, that sort of element of knowing, not knowing that there will be harm, but knowing that there is a risk of harm, that might in itself be gross negligence.
But this language establishes like a high burden of proof and a high standard for actually overturning government policy with this paragraph.
Definitely. Yeah. But I don't think that is necessarily the standard for other kinds of government decisions than parliamentary decisions. So I think this has to be read on the background that what the court discusses here is the threshold for overturning parliamentary decisions. The underlying value here is, of course, democracy.
I just wanted to add that I checked now and they used gross negligence and safety valve both.
Yeah, exactly.
Yeah, but I think we've now touched on everything we wanted to talk to you about. It's been very interesting and fruitful discussion, I hope. So thank you again for taking so much time. It's been a pleasure to talk to you.
Thank you for having me, and it's been a pleasure to talk to you as well.
Thank you.
Thank you. So this wraps up our interview with Ivar Alvik. Konrad, what do you think?
Well, I think that we learned some more about the permit process, which I still think is kind of complicated, but combined with our interview with Professor Voigt, I think we now know a bit more about how it works. And with these two different legal professors, I think it's also interesting to point out the difference that Ivar talked about, that if the Supreme Court had sided with the plaintiffs in some of these specific points here, that they would have made the Constitution more of a political tool. And Christina seemed to think that the decision of the court to not do anything was actually making a political decision by trying to avoid to make a political decision. So I think that it's very interesting. What were your thoughts after it?
I think that professor's view about balancing the global climate implications against the benefits of Norway from increasing Norwegian production are interesting, because professor said that that would be close to a pointless exercise because benefit will be very tangible, while on the other hand, global implications will be quite limited because they will only form part of all the accumulated effect of oil global emissions in the world.
And I think that really just goes to the heart of one of the major problems with climate change, of course. So it's interesting to hear several sides of those viewpoints, I think. And just in the end, I think it was a fruitful conversation, and that we learned a lot from. But luckily, our other interviews with, among others, some economists that did a review of the impact assessment before opening this field, we can have a closer look at what tangible benefits there actually were to Norway in this case, and how you could compare that to damages in other countries. So thank you for listening to this episode, and we'll see you in the next one.